Good morning and welcome to the First District Court of Appeals. We have two cases to be argued this morning. The second one will be over Zoom. The first case is State v. Wright. If the attorneys could please stand up, say who you're representing, and your readiness to proceed.
Good morning, I should say. William Gallagher on behalf of the appellant, Mr. Wright. Good morning, Your Honor. John Hill at
Okay, thank you. And I will be using the light system. So when you see the yellow light, you have about a minute. Red light means your time is up. Mr. Gallagher, would you like to reserve any time?
If I could reserve 3, I'd appreciate it. Thank you.
Absolutely. Whenever you are ready.
May it please the court. Counsel? What I'm asking this court to do is find that the dog trained after the change in Ohio law and in federal hemp laws cannot provide probable cause to search a motor vehicle without a warrant.
And that's just, you're saying that for any dog, is that right?
Well, I'm saying that a dog that has marijuana within its category of drugs that it alerts to. Mm-hmm. I think of a dog, obviously, and you know, we can read newspapers that dogs are now being trained without marijuana as a result of this. And Officer Lang put his dog into service after the change in the laws with marijuana.
This is pre-constitutional amendment, right?
Excuse me?
This is pre-constitutional
Correct.
amendment.
It was. This was at the time when the laws had changed about hemp and that they changed about medical marijuana. So we had Ohio medical marijuana on the books, and we also had the change in the hemp laws where 3% THC and below was no longer illegal in Ohio, and they redefined hemp so that people could legally possess hemp products, low-level THC products in the law, and that was all changed before Officer Lane got his dog and put his dog into service. He admitted that he put his dog into service afterwards, and that it could not distinguish between legal and illegal hemp. In fact, he even cited an instance where his dog alerted and all they found was legal hemp.
Let me ask you this, Mr. Gallagher. Fentanyl is illegal in circumstances where it's prescribed. So would your argument apply to fentanyl as well? If somebody has a prescription for fentanyl, cancer, extreme pain, would you say that that's not probable cause anymore if it alerts on fentanyl?
I think you have problems with that, and the reason we have problems with that is how dogs got used in the first place, legally speaking, in constitutional search cases. Dogs, we used to be able to attack reliability of dogs, and then it moved on to the law became a certified dog was considered to be reliable for purposes of probable cause. But it was because of United States versus Place that came into place, into being. Because what Place talked about was the dog was never going to alert on legal substances. What Place said was the Sniff discloses only the presence or absence of narcotics, a contraband item. It was for that reason that dog sniffs were permitted to be probable cause for a car search, is because the United States...
Let me ask you this. Like, if an officer sees a white substance covered in plastic wrap, it may be drugs, it could be laundry detergent. Like, the officer doesn't know at that point. But doesn't that give the officer probable cause to take the next step to figure out, to arrest the person, to do a search, to do something based on something that looks like drugs, but it may not be drugs?
I think it would require a little bit more than just the fact that someone is possessing a white powder substance to be able to do that. Is the person holding that out to be a drug? Is the rest of the other circumstances that gives rise to that indication?
Well, we're talking about probable cause here, right?
We're talking about probable cause to search, though. We're talking probable cause to search without a warrant. Mm-hmm. And that becomes a bigger issue, which is what we have with Place and then Caballos, because Caballos, it was then reiterated on it because, and the question was there, Caballos said that the search depended on a well-trained narcotics detection dog to not expose non-contraband items that would otherwise be hidden from public view. And that was a problem, if you remember the Kylo case with the infrared intrusion into one's home, that one of the things that they were concerned about in that sort of trespass Fourth Amendment issue was that you were exposing otherwise legal activity that someone might want to keep private in their home, and that search failed when they used the infrared because it couldn't do with what Caballos and Place said about a dog, which was it did not expose non-contraband items to exposure. And that's the problem when all of a sudden you don't change your behavior with the law. And that's what the police chose to do in this case, was go away from Place, go away from Caballos, and take the chance that they were, because the dog could alert on non-contraband items,
So it's your position that the dog must be 100% perfect before it can be used?
No, I'm not saying that. What I am saying is that the dog should be reliable only to contraband items. And what the law said is when we used to be able to attack reliability of dogs, there was a time when there were motions to suppress and determinations based on whether a dog was hitting 60%, 70%. At what point did the dog become reliable? And the law changed and said, no, if a dog is certified by the state certifying agency has been, we will presume that dog to be presumptively reasonable. But the reason is it would only, at the time, expose contraband items. Cocaine, marijuana, which was completely against the law at the time. It was not including prescription drugs within its library. It was only illegal contraband items that the dog was allowed to alert on. And that's why the law changed, because the dog was presumptively reliable. The problem here is what the law officer did in this case, which was go now and include in that dog's library, and after the change in the laws, include in that library substances that were legal. And it's for that reason it becomes a problem. I mean, I think it flies in the face of what Pace and Caballos tell you.
Mr. Gallagher, can you distinguish the cases out of, it looks like the 7th, the 5th, and the 8th that have held that as long as some forms of marijuana remain illegal, more is still good law?
Correct. Well, let's start. More, first of all, is only with it was a trooper smell case, and all the cases after that are all cases in which there are police officers that were smell. And in every single one of those cases, Place and Caballos are never even discussed. They're not discussed in the briefing by the appellant. They're not discussed in any of the appellate decisions at all. There is none of that. They just all go to, in the first case, Tillman goes to Moore and cites Moore and says it's still good law and it's fine. Every case after that just cites the exact same quote and does no other analysis other than say, well, Moore's still good law, so then that's all there is to it. But the problem is that it doesn't even discuss the Fourth Amendment analysis of Place and Caballos. And I would ask this court, if you do so, you come up with the problem that the language is really, really explicit about the dog sniff. And that's, I think that's the sort of stumbling block that the state has to have in this case, which is, what do you do about Place and Caballos in terms of what the United States Supreme Court has dictated to you in terms of how you analyze a dog? And then when you knowingly throw a dog into service that is exposing those items. Officer Lang testified, and what he says is you can do extinction training. You can remove smells from a dog's library. You could decide, because the law has said that marijuana is now legal in some forms, medical marijuana, hemp is legal, hemp products are legal, to take it out of service, take that smell out of its library and move forward. And that's exactly what should have happened here. They should have either got a dog without it, but they decided to put that in there. And because of Place and Caballos, I think that's the big problem.
And if you found any cases, either in Ohio or elsewhere, that has mandated the rule that you just articulated?
No. No. I will tell you, I think that you're going to be a case of first impression in the state of Ohio if you decide to do that with the dog. But I also don't see any case in the state of Ohio where the argument about the dog has ever been raised and shut down. And so, I mean, we got to start somewhere, I guess, and it's me that's asking you to do that.
Let me ask you this, Mr. Gallagher. Assume that the officers that stopped your client were federal officers, and there was some way they could take it into federal court. You'd get a different answer, right? Because my understanding, marijuana is still illegal under federal law. So you have the federal court down the street, you have the courthouse over there. So depending on who arrested your client, would it be a different result?
I don't know. I haven't had time to really sort of think about whether or not the challenge can be raised in federal court in any sort of form or that.
Or if you're right, from now on, what would happen, like they do with the gun cases now, they stop somebody with marijuana, they just take them federally and don't even take them to state court.
Well, I think the issue that you have, however, still, and I don't know because I haven't started to do, is what you do about the federal hemp laws. Because federal hemp has
That's
been
true.
redefined
Okay.
federally
You're right.
all the way through, and I haven't thought time about whether or not their dogs have hemp within their library or not, and then they may not do that. They may have done what at least it's they're taking dogs completely out of service in Ohio, where those are at this point, but that's all after the fact. After I think some of these issues have come up, that they've begun to realize that there shouldn't be dogs that are smelling marijuana, because it does come into problems with place and compose.
Mr. Gallagher, can you please address the state's argument that even if we took the dog out of the equation, there was still probable cause based on your client's behavior, leaving the hotel, and, once the pulled onto that cul-de-sac?
Absolutely. So you first have Officer Beckwith, who basically said, no dog smell, no search. So even the officers admitted that they were not on legal ground without the dog search. So they themselves at that point in time didn't think that they had it. I know the state afterwards is saying that's the case. What do you have? You have somebody going into the front entrance or the normal entrance at checkout time, going into a hotel, coming out of the hotel with a piece of luggage, which is not, and one of the officers admitted, it's really not unusual to see someone come out of a hotel at checkout time with luggage. He said it's a high crime area, high trafficking area. Didn't see any indications whatsoever that there was drug dealing going on, other than he thought that the behavior was somehow suspicious. And the suspiciousness was in a high crime area that someone looked around, as if casing or looking around to see if anybody was watching them or not, which I guess if you're, depending on your perspective, if you're a police officer looking for drug activity, you think that's suspicious activity. If you're somebody who says someone's in a high crime area and is carrying their belongings with them to a car, that they may want to make sure that there's no one around there to cause them problems. But at any rate, one officer thought that that was suspicious. He thought it might be evidence of a drug deal. Without any real objective facts, it was a subjective conclusion based on objective facts that don't rise to that level at all. Then there's a traffic violation, and then there's a dispute among officers as to what the behavior was after that. One officer wrote in his report that he followed the car until he could have proper backup and then pulled it over in a cul-de-sac. Another testified that the car was slow to stop and a problem. So there's confliction within the officers in terms of exactly what the behavior is after the traffic violation. I would suggest a traffic violation is not any evidence of drug activity. And in fact, I guess if you read the cases on it, it's the careful driver doesn't commit any traffic violation that gives a greater rise to someone trying to avoid detection. But after that, it was supposed to be a traffic stop. It clearly wasn't. He was calling backup for a traffic violation. It was clearly a drug investigation. They admitted it was a drug investigation. It used a traffic stop as the reason to pull him over. And I think that that is supported by the idea that they never once asked him for his license or registration. The immediate was get out of the car, and when he questioned it and challenged the officer, was, I'm going to break the window. It clearly was never a traffic stop, or at least going to be treated as a traffic stop. There was never going to be any of that. But I would suggest that there is nothing within that behavior at all that gives rise to the idea you can search the car. No. Thank you.
Thank you.
If there are no other questions right now, okay, thank you. Good morning, Your Honor.
Good morning.
I have very little to add to this discussion. A lot of the points that I raised in my brief were already kind of touched on during Mr. Gallagher's argument here. I do want to clarify the state's position relative to the probable cause determination. We're not arguing that probable cause necessarily arose just without the dog. It was everything else that we talked about here, the high crime hotel, the fact that the defendant arrives at this hotel, cool as a cucumber, walks in, walks out a few minutes later with this big duffel bag. Suddenly he's looking over his shoulders. The fact that he was evasive when Deputy von Herzenberg started to tail him, the fact that he was speeding, the fact that he made several turns, the fact that he was completely uncooperative.
I'm sorry, was that a marked or unmarked car?
It was a marked cruiser. Okay. Deputy von Herzenberg's cruiser was marked. So he was aware that it was a cop tailing him. He was completely uncooperative with Deputy von Herzenberg, wouldn't even roll down the window when he was pulled over. And then you have the dog after that, because probable cause demands you look at the totality of the circumstances here. As to the probable cause determination from the marijuana sniff, I would just reiterate that marijuana does, well, at least at the time of the stop at issue in this case, was illegal, it was contraband under most circumstances. The 5th District got into this, I think, in the Tillman case. 7th and 8th District said the same thing, as long as marijuana remains contraband. And I know it was in the context of an officer making a sniff. The only distinction there, I would say, is the dog has a more powerful nose. As long as understanding that probable cause is really more of a common sense probability determination. It's not quantifiable. It's not even 50-50. When you've got a dog that's only trained to hit on fentanyl / heroin, cocaine, amphetamines, and marijuana, which is, again, contraband.
And so, like, how would the calculus change in the wake of the constitutional amendment?
I don't live in Ohio. I live in Kentucky. So is marijuana constitutionally protected in Ohio, or is it statutory? I was under the understanding it was statutory. I know it was constitutional in the McKnight case that Mr. Gallagher cited in Colorado.
I mean, they passed a constitutional amendment, so.
Was it a constitutional amendment? Okay, I'm not up on my Ohio electoral politics. I don't think it changed. Well, it may change the calculus now that it's under most circumstances, but that was not the issue in this case at this time. So that would be our position.
Well, I think what Mr. Gallagher is arguing is that you have a dog who's trained and can't distinguish between certain legal substances and certain illegal substances. So, like, another way of thinking about it is if the dog, if there was a trunk full of dog treats and it, like, alerts on that because it's hungry, like, how do we gauge the dog's ability to distinguish between legal and illegal substances?
Well, I mean, relative to the dog treats, I don't know if the dog is probably trained off to not hit on a trunk full of dog treats. I would assume that would be part of its training in that circumstance. I can't speak to that. Now, relative to this, again, we're dealing with probabilities here. So you have to ask yourself, under these circumstances, you've got this guy that's coming out of a drug trafficking hotel, and then he's acting pretty evasive and cagey about everything, and then this dog hits on the trunk. So what's the more likely possibility here, that Mr. Wright has a trunk full of commercial hemp, or that he's got some kind of an illicit substance in a duffel bag? So dealing with probabilities, that would be my response to that. You have to look at the totality of the circumstances here.
So the testimony about the hotel itself, I know that there was testimony that they were investigating, that they were doing an investigation at the hotel. Was there actual testimony that it was a known drug hotel?
I would assume, I believe Mr. Gallagher and I were both operating under that assumption here. These deputies, they do these sting operations at these hotels that they know to be known for high drug trafficking activity. They're watching these hotels for a reason. So I would say that's probably a fair assumption if it was not explicitly contained in the record.
Okay, thank you.
Any questions? No? Thank you.
Mr. Gallagher, you have about 3 minutes.
Yeah, I think the Supreme Court and everyone has already talked about over and over again about high crime area and someone's presence in it really can't be a factor in it. There's no objective fact that gives you that conclusion that there was anybody involved in that parking lot in drug trafficking just because they were there to watch someone else. In fact, Mr. Wright was, one officer said he didn't find most of the behavior odd in terms of if you were a hotel guest. But what it is about the dog losing its reliability, isn't it? I mean, that's really what we're talking about. And that's the problem, is the dog is no longer reliable to uncover contraband. And the officer only has probable cause when he discovers reliable information to conclude that he will find contraband. And that probability and all that reliability is now drastically dropped because of the use of a dog with marijuana and legal forms of marijuana within its library. And it's that reliability that I'm asking you to determine just basically as a matter of law under place and
Do you know, like you mentioned the certification process, just out of curiosity, do you know, like, is there a requirement that a dog meet a certain threshold of accuracy to get that certification?
I don't know what, I can't remember if it was 80% or 85. This is when I used to be able to attack the reliability. I used to have all these trainers on the stand. Since we did change in the law, I no longer get to do that. So I don't know if that has since changed. But you know, it was just sort of funny. Mr. Hill was talking about dog treats, and you're asking about dog treats. My law partner, Hal Aaronstein, told his boy, he was a tennis player at Sycamore, and they pulled him out because the dog alerted onto his car. When they opened the trunk, it was a basket full of tennis balls. It turned out the dog's reward for finding substances was tennis balls. And that's just, it was just sort of funny, but everyone's expectation is they were going to find drugs in it. Maybe that dog didn't have enough extinction training. But because of the fact that we're not slowing down an officer's ability to do an investigation, but we're now changing the tools a little bit and say if you want to use a dog to do drug investigations, it's got to be properly trained, but it has to be reliable. And in order to be reliable, it should only be trained on contraband so that it conforms then with place and Cabales, which says you shouldn't be exposing, and that's what it says, not exposing non-contraband items to exposure. And in compliance then with the same language in Kylo. Which also talked about the same thing. And now those laws haven't changed. The only thing that changed is the way we have marijuana in this state, and as a result, the police just needed to catch up and chose not to. And that's specific, I think, the other case. They chose not to. They don't even get to say bad faith or good faith in this argument. Thank you very much for your time.
Thank you. Your case is now submitted, and we will issue a timely decision. At this point, the judges will take a short recess, and we will restart session over Zoom. Thank you.